Hello everyone, welcome to our channel PH Webgyan Videos. So this is part second of my earlier video on prevention of oppression and mismanagement of the affairs of the company under Companies Act 2013. So earlier we have already discussed that what this concept is all about and what all members have the right to apply for the relief for prevention of this oppression and mismanagement. And secondly, the members, if the conditions are fulfilled, then the members can apply to the tribunal under section 241. Okay, so we all know that the powers for granting relief with respect to this prevention and of oppression and mismanagement is with the tribunal. Clear? So today we are going to discuss about the powers which are having which the tribunal is having with itself, okay, and what all orders it can pass or what all matters can be incorporated in the orders that the tribunal pass in order to grant relief for the oppression and mismanagement. So let us proceed. Now section 242 subsection 1 simply provides that if any application is made to the tribunal under section 241, which we have already discussed. So if any application is moved or if any application is provided or made to the tribunal, and if the tribunal forms an opinion that the company's affairs are actually being conducted in a manner which is prejudicial to the members or prejudicial to the public interest or prejudicial to the company itself, or it is oppressive to the members, then it can pass an order for granting of relief, and this order can contain any such matter which it deems fit. Clear? However, this is not the only point which it should form opinion of. The other point, it says that if the tribunal is of the opinion that if the facts are seen apparently, then the facts are being shown in such a manner that the winding up of the company seems to be just and equitable. But the actual scenario is that the winding up is actually harmful for the members mentioned above. Okay, so in that case, the tribunal can pass the order. So it simply says that if the tribunal is of the opinion that firstly the company's affairs are being carried out in such a manner that it is harmful to the member themselves, or it is harmful to the public interest, or it is harmful to the company. Clear? First of all, the condition is this, that the tribunal should form opinion with respect to this thing. Secondly, if the tribunal itself sees that the facts which are being shown, it says that the winding up is just and equitable and it is justified. However, the actual scenario is that the winding up will actually harm the interest of the members. If the company is being wound up at this point, then it would be actually harmful to the members specified above. Okay, so in that case, the tribunal can pass the order. So apparently the fact says that the winding up is okay, but it is not actually. Okay, so in that case, the tribunal may, with a view of bringing an end to the matter which has been complained of, make such order as it may deem fit. Now, what these orders should contain, we will be discussing it in our next slide. So section 242 subsection 2 provides that without prejudice to the generality of the powers under subsection 1, since subsection 1 is a very general thing, okay, general section, which simply says that the tribunal has the power, only it has to form the opinion with respect to 2 points, and if that is being done, then the tribunal can pass the order in such a manner as it may deem fit. Okay, so this is the general power given to the tribunal. However, subsection 2 says that without harming those powers, there are certain things that the order may include. The word is may. It is not mandatory that these points are only going to be included. It may include. So the order passed by the tribunal may include or may provide for the following. First of all, the tribunal may pass an order for regulation of the conduct of the affair, because that is the only thing which is not being done properly in the company, which is being complained of. Okay, so first of all, it is regulation of the conduct of the affairs. Secondly, it may pass an order for purchase of shares or interest of any members by other member or by other company. Okay, so the shares or the interest of the member can be purchased by either member or the company. This can be provided in the order. Okay. Thirdly, it says that in case of purchase of the shares, as is mentioned above, the consequent reduction of the share capital. Now, if the shares are being purchased by other member, then there would be no possibility of reduction of share capital. However, if the company itself purchases the share consequent upon the or the pursuant upon the order of the tribunal, as is mentioned in clause B, then in that case, the consequent reduction of the share capital should also be included in the order. Clear? So firstly, it was regulation of conduct of the affair. Secondly, it is about purchase of the shares of the company or of any member by other member or by the company itself. But if the company is purchasing the share, then the order may also provide for the reduction of the share capital. Clear? Fourthly, the restriction on the transfer or allotment of the share. So the tribunal can pass that there are certain restriction on the transfer or allotment of the shares so as to actually restrict the management or the affairs of the company so as to bring relief to the members who have complained this. But before granting these orders, it has to be satisfied that the point is actually being done in the company. Clear? Now, another point is termination, setting aside modification of any agreement. Clear? So it says that if there was any agreement, so if tribunal is of the opinion that this agreement should be terminated or either it should be set aside or it should be modified so as to provide relief to the members who have complained of this mismanagement and oppression, then it can also do so. Howsoever arrived at between the company and the MD or any director or manager. So this agreement is between the company and the MD or any director or any manager upon such terms and conditions as may in the opinion of tribunal be just and equitable in the circumstance of the case. Okay. Now, another point is termination, setting aside modification of agreement. All the things are same, but now the agreement is not between the company and MD or director or manager, but it is between the company or any other person apart from those mentioned in point E above. Clear? So it is again with the power of the tribunal that whatever it feels that is just and equitable in the case, it can set aside the agreement or it can terminate the agreement, it can modify the agreement and upon such terms and condition as it may deem fit. Okay, so everything is upon the tribunal now. Yeah. Now, provide sorry, provided that no such agreement shall be terminated, set aside or modified except after due notice and after obtaining the consent of the party concerned. Since the agreement involves two parties, the company and the other person, it could be MD, director or any other person or manager. So the agreement cannot be terminated or set aside or modified except the due notice is given. It can only be done after giving due notice and obtaining the consent of the party which are being concerned. Clear? Without which it cannot be done so. Why? Because it would otherwise harm the second party. Okay. Now, setting aside of any transfer, delivery of goods, payment, execution or other act relating to property made or done by or against the company within 3 months before the date of application. Now, if any such thing is being done 3 months prior to the date of application made, clear, it could be transfer, delivery of goods, payment or any execution or any other act related to the property which is done either by the company or against the company. How much time before? 3 months before the date of application. Clear? Which would, if made or done or by or against an individual, be deemed in his insolvency to be fraudulent preference. So now this is the very important point which says that if the the such act is done by the individual, and in case of his insolvency, if it is considered to be as the fraudulent preference which is done intentionally to set aside his liability, then this, if the same act is done by or against the company within 3 months of the before the date of the application, then in that case that transfer or delivery of goods or any such acts related to the property can be set aside by the order of the tribunal. Clear? Now, another point is removal of managing director, manager, or any of the directors of the company. So, this could also be done by the tribunal's order. Another point is recovery of undue gains. Now, if any undue gains is being made by the MD, manager, or director during the period of his appointment, then in that case, recovery of such undue gains could also be included in the order of the tribunal. Moving forward, now manner in which managing director or manager may be appointed subsequent to an order removing the existing managing director or manager which was given under clause H. Now it says earlier previous clause we have read that the managing director or the manager or the director can be removed. Now the tribunal can by its order also prescribe the manner how the new MD or manager is to be appointed in place of those which are being removed by the order. Clear? Now, another point is appointment of such number of members as director who may be required by the tribunal to report to the tribunal. Now, these will be the directors which are being appointed by the tribunal so as to report to the tribunal any such matter which it requires. Clear? Now, another is imposition of cost as may be deemed fit by the tribunal. It is again upon the tribunal to decide what all cost is to be imposed by the order on the company. So that can also be included in the order. Lastly, it is again the general point, any other matter for which, in the opinion of the tribunal, it is just and equitable that the provision should be made. Clear? So I hope these points are clear. They were general, and the thing is they may be included in the order. It is not necessary only these points are going to be included in the order. Okay, because subsection 1 is general and subsection 2 only provides certain points which may be included in the order being made by the tribunal. Clear? Now, subsection 3 of section 242 provides that the certified copy of this order is to be filed with the registrar of the companies within how many days? Within 30 days of the order of the tribunal. Clear? Now, who has to file this? The company. Now, subsection 4 provides that the tribunal can also make any interim order if it thinks fit. Okay, interim order is the order which is made before the actual order. Okay, this interim order which is in between the order, it could be for the regulation purpose of the conduct of the company's affairs. Clear? Now, another point it says any alteration which has been made by the tribunal in the memorandum or the articles of the company because of the order, then afterwards the company cannot make any such alteration which is inconsistent to that order. Okay, however, it can do so if it gets the leave from the tribunal or if it gets the consent of the tribunal. Another thing is that if the order itself have permitted certain extent to make alteration in the memorandum or the articles by the company, then the company can do. Otherwise, the company cannot make any alteration which is inconsistent to the order made by the tribunal. Clear? Now, the alteration which have been made by the order in the articles or memorandum shall have the same effect as they have been duly made in accordance with the provision of this Act. Clear? Now, the certified copy is also to be filed with the registrar with certified copy of every order which is altering or giving leave to alter a company's memorandum or articles. Clear? First of all, if the order is giving the alteration of the memorandum or articles of the company, or secondly, if it is giving the leave of alteration, then both the orders or any of the order, as the case may be, has to be filed by the company with the registrar within 30 days after the making of the order. Clear? Now, if any of the provisions of the section has been contravened, then in that case, the company shall be imposed with a fine of at least 1 lakh and a maximum of rupees 25 lakhs. Okay, now officer in default, we all know what is officer in default. So it will be actually be punished with the imprisonment for a term which can extend up to 6 months, or with the fine which shall not be less than 25,000 rupees, that is minimum of 25,000 rupees and a maximum of 1 lakh rupees, or with both. So imprisonment or fine or with both. Clear? So this is the punishment of the officer in default. Now, another important point is class action suit. So this is the new concept, which is a new initiative introduced by the Companies Act 2013 to safeguard the interest of minority shareholders. Okay, so now what is class action suit? Class action suit is a lawsuit where a group of persons is representing a common interest. Okay, and they can approach the tribunal to sue or be sued. Okay, so suppose there is a large group of person who are having the common interest, they can approach to the tribunal for relief. Okay, so this is the procedural instrument wherein a large group of person having common interest, they will form a class. Okay, so one or more plaintiff can actually apply to the tribunal for relief on behalf or for the benefit of that entire large group of persons having the same interest or common rights and grievances. Clear? So this is all about class action suit. Now section 245 of the Act deals with the provisions of class action suit. I'm not going to discuss it in detail. If anyone requires that this should be discussed in detail, they can mention in the comment section of this video. So I am done with this video. I hope you have liked this video, and if yes, then please like and subscribe. My YouTube channel is PH Webgyan Videos. Do not forget to share and comment on this video, as your comments are valuable, so please do. Thank you.